Hello, estate planning mom here, Crista Hermance. So I am live with you answering your estate planning questions. So if you have any questions and you're just joining me, please make sure to post those in the comments so I can try and get to those. If you don't feel comfortable posting in the comments, you can always send me a direct message or send me an email. I can get back to you directly, or I can cover it in next week's questions and answers. So I'm here every Wednesday night at 6 p.m. Answering any of your estate planning questions that you have. So if you're just joining me, please make sure to, again, post your questions, and I'm going to get started here. Okay, so first question. Should I use a legal drafting website to create my will? What are some of the cons of it? So this is a really great question. I do have people a lot that ask, why should I not use an attorney or a will drafting software to create my plans and use an attorney instead? So I have seen multiple cases, one in particular that I actually just spoke with somebody about today, where the intention that they have for the documents that were created weren't actually completed by using this will drafting software. And I think the reason for that is that maybe they have this idea of what type of estate planning documents they need. Maybe they go into it thinking, okay, well, I just need a will. But they don't understand what having a will actually will accomplish for them, because a lot of times people have this idea of what a will does, but in all actuality, it doesn't do what you think it's going to do. And I think that's really where an attorney comes in, and specifically when, as us as estate planning attorneys, is we're able to explain the differences of what having a will accomplish according to what your wishes are, and then maybe what other planning tools are available that you wouldn't necessarily think of if you weren't having that conversation where we were going over what your concerns were. In one specific example, I know that I had a client that came to me that they purchased a whole will and trust through an online software company, and they were overwhelmed by the questions that were included. They didn't know what to respond because there wasn't anybody to talk through it with them. So the whole process was very overwhelming. So they spent a lot of money on this whole drafting software that they never actually used, because then they came to me and we created a whole plan that was exactly what they wanted, and we did everything for them. So I think that's, it's just one of the things that if it's something that you want and you need assistance with, because you want to make sure that it's getting done the way that you want it to get done, then I think that's where having an attorney come in and be able to guide you in choosing the right tools to be able to use, as well as answering questions on, who should service specific agents for things, what type of qualities do they need to have. These are things that I think it's important to have an attorney working with you. One other very specific example that I just recently heard of from somebody that I'm helping is and this was before they knew me, so they went online because their parent was sick. And now that I think about this, I had another client that did this too, but specifically relating to somebody that this just happened to, I just found out about it. They had a parent that was sick. They went on to an online drafting tool and created a will and had the will signed, and the parent passed away shortly thereafter. Well, they didn't understand what having a will actually meant for their estate. So in California, which is where I'm licensed to practice law, having a will guarantees probate court. A lot of times people think that having a will prevents probate court, and that's just not the case. So this will that was created, they did this in the false pretense that it was going to prevent probate, which it didn't, because they owned a home. And so all the will did was tell the probate court how they wanted their stuff distributed, but they still had to go through the probate process. And so, it's now coming up over a year since their parent had passed away that it's just finally finishing up. And so all of this preparation that they did by creating this will online gave them this kind of false hope that everything was the way that they expected it to be. But then the family, once the parent passed away, they still had to go through probate, and they had a house that had to go through probate. And the fees associated with probate are very, very expensive. It's set by statute. So it's not something that we make up as attorneys. It's actually set by statute by California law. And so all of these fees were then had to be paid as part from this estate because they owned a home. And if you own a home in California, you know, it's not cheap, right? You know, it's somewhere between $500,000 to $800,000 in that asset. So just that one asset going through probate is very expensive, like tens of thousands of dollars in fees. And they thought that they were preventing this by doing the will when that just wasn't the case. And so that's why I think working with an attorney will help you understand, am I using the right tools? Am I using the right legal documents to make sure that I am distributing the stuff that I want to, the way that I want to, and providing it in a manner that's going to avoid this long court process, that's going to save a ton of money on fees. And I think that's really where the value comes in. I do remember one other case that I had where a client was going away on a trip, and I see this a lot where parents are going away and they're concerned because they don't have any planning documents for their kids. So they quickly go online and they do a plan. And in this document, once they came to me after the trip, they brought me the documents, and the guardianship document that they were preparing for their kids, the way that it was, the text was structured, I was reading through it, and they went from nominating guardians to their kids to actually nominating a conservator for themselves if something happened. And so something happened in the document where the language switched and they weren't actually doing a guardianship nomination anymore. They were naming a conservator for themselves. And they signed this legal document and thought, okay, my guardians are named for my kids. And so it wasn't until I read through it that I was able to point out the language to them and show them, hey, look, I don't think this is what your intention was, because this is what it says. And so they were completely caught off guard when seeing this. So again, I understand it's less expensive, but it can save so much money and so many issues by working with an attorney rather than working with an online drafting software. Okay. So I hope that answered your question and gave you some other insight into, why I think there's a lot of cons in doing it. If you have any other questions and I wasn't able to answer that all the way, or if you have other questions about that, please always feel free to email us info@hermanselaw.com. You can always visit our website, www.hermanselaw.com, for more information. And then also, if you have questions about estate planning, you want to get an appointment set up, you can do that on our website. You can also call or text us at our office, 805-518-9633. Okay, if you're just joining us, thank you so much for joining me. I'm here every Wednesday answering your estate planning questions. If you do have any questions, please make sure to put them in the comments so that I can try and get to those for you. I'm going to go to our next question here. Okay. I have godparents named for my kids. Is that enough when nominating guardians for them? So that is a great question. I do hear that a lot from people when I say, do you have guardian names for your kids? And they say, oh, I have godparents, we're good. So when you have godparents named for your kids, or you have, people that are in that kind of godparent role that you have in your family, whatever, that tradition is, it doesn't actually legally name them as a guardian for your children. So you have to go one step ahead. If you want them, that if something happened, you would want them to be named as guardians for the kids, it's important that you have a legal document that actually says, if something happened to you and the other parent, that these are the people that would be guardians. And then you date it, you sign it, and then you either get it witnessed or notarized, depending on where you are, so that it makes it very clear to a court. Because without having that guardian nomination, if something happened to you and the other parent, and the godparents petition the court, well, at this point, the court has no idea if that's what your wishes actually were. Because what if somebody else also petitioned the court for guardianship of your kids? And then at this point, you have nothing in legal writing or any legal instructions as to who you would want to be guardians. So the court doesn't know what your wishes are. And that's why it's so important that even if you have them named as guardian or as godparents for your kids, having it legally documented that says, yes, I want them to be guardians of my kids if something happened, then it makes it very clear to the court that this is who you've nominated. This is who you've said, if something happened to me, this is who I would want to raise my children. Okay, so that's why it's so important to make sure that you have that document, because without it, again, the court doesn't know you, they don't know your kids, they don't know the family dynamics. They don't know, right? They don't know anything of what's going on with your situation. And so by you having this documentation, this legal documentation that says who you want the guardians to be, it lets the court know what your wishes are. Okay. Okay, if you're just joining us, thank you so much. Make sure to post your questions in the comments if you have any questions. Let's see. And always feel free to email us, info@hermanselaw.com, if I wasn't able to answer any of your questions today, or you want to email me specifically. Okay, let's get to our next question. Okay. Should I list my kids as a backup to my husband on my life insurance policy? Okay. So for this question, I see it a lot for parents that come in for planning where they have life insurance policies for themselves and their spouse, and they have each other listed as the beneficiaries, and then they have the kids listed as the backup. That's probably 85% of the time what I see in life insurance policies or beneficiary designations on life insurance policies. And so I think a lot of people don't really think through the impact that can have, that when you have a life insurance policy and you have your spouse listed, if something happened to you and your spouse, then the kids would get the money, which is what you would want, right? You want your kids to get your money if something happened to you. But if they are a minor, they can't actually receive that money. So that money would have to go through the court to be able to be given to them in a court blocked account where the court would assign somebody to monitor on their behalf. And then they would get all of it when they turn 18 years old. And for some insurance policies that are very high, that's a lot of money. You know, you could be talking about $250,000, $500,000, $1 million from life insurance benefits that a 18-year-old kid would be getting when they turn 18. And they probably aren't financially mature enough to be able to receive that type of money at 18 years old. And so it wouldn't be necessarily a good thing for them to come into all of that money. And so generally when I see clients in this situation, it's because we're doing planning for them. And that's one of my favorite tools about having a trust. And so this is our trust plan that we have. And what it does is when you have a trust, revocable living trust, it allows you to list your life insurance policy as, on your life insurance policy, you list the trust as the backup beneficiary. So that if something happened to your spouse and yourself, then rather than that money going to your minor children to be distributed through the court system, then it would go to your trust to be distributed at the ages that you set according to your trust instructions, like 25, 30, and 35, rather than all of it at 18 years old. And that's probably one of my favorite things about having a trust when you're a parent with minor children, is the flexibility to do that and to have those instructions in place, to keep it out of court, to keep it private, to keep the cost down for managing it. I do have one quick story to share that involves life insurance and minor children. So I was working at an event one time, and I had a mom come up to me, and she had 3 little girls with her. And we're talking, and she says, you know, I recently lost my husband. I said, I'm so sorry to hear that. How are you doing? And she said, I'm okay. He had a life insurance policy. I said, well, that's great. That's going to be really great to help you. And she says, the only issue is that for whatever reason, he named our minor girls as the beneficiaries. So he didn't even name the wife as the beneficiary. He named the 3 girls as the beneficiary. And this wasn't a second marriage. It was the first marriage. It was all 3 of their children together. And he named the kids. And, you know, just kind of thinking through it, like, of course, the intent was that he wants his kids taken care of. But the impact of naming his kids rather than his wife was that these girls were minors. So the wife said, I said, what's going on with life insurance policy now? She said, well, at this point, I have to go to court to be able to get it released to me on their behalf. and I just don't have the emotional capacity to even have to deal with that. So she had this very large life insurance policy that she wasn't even touching because she had to go to court to get it released to her kids, for her to be able to use for them. And so again, I don't think it was the husband's intention, but by not having somebody to kind of talk through what the ramifications would be, it was this consequence that I don't think that he really understood was going to happen. And so that's why it's so important. And this is a great exercise. If anything, go find all the accounts that you have, get the information together, pull a statement, put them in a binder, get your stuff together. Look at the beneficiaries that you have on all of your accounts and see, are they the actual beneficiaries that you still want? I have lots of clients that I see all the time where they maybe forgot about a retirement account that they had maybe 10 years ago, and they've gotten married, they got married maybe 5 years ago. And their new spouse wasn't updated as a beneficiary on this policy, or maybe they had an older spouse listed as a beneficiary. So that's why it's so important to, always kind of be mindful of these beneficiary designations and check them. So, great exercise, go and check all your beneficiary designations, check your spouses, or have your spouse check theirs, and make sure it's actually who you want to be the beneficiary. One other thing that I will mention about the beneficiary designations when it comes to life insurance with minor children is I've had discussions with other people where they say, well, I didn't want to name my minor children, so I named my sibling. And I see that happen often where they know not to name their minor kids because they don't want the minor kids to get the money because they're minors, but they name a sibling. So the issue that I have with that is that when you name somebody just outright as a beneficiary, they have no legal documents or legal agreement like a trust to follow that says that this money is for the benefit of their kids. Right? It's basically just them listed as a beneficiary, and they get a check made out directly to them. There's nothing legally in writing holding them to what we call a fiduciary responsibility to make sure that that money is going to the benefit of the kids. It literally just goes into their checking account. They can do whatever they want with it. And I mean, obviously you think, well, they're my sibling, and of course they're going to take care of my kids, but there's nothing legally holding them to do that. So if there's any wrongdoing and, to bring a case against them in the future, somebody to do that, there's nothing that says that that sibling had to use that money for that specific purpose. And that's really where I think the trust comes into play, is because the trust has very specific instructions on how to use the money, how you want it distributed for the benefit of your kids. It would have your sibling listed in there as what we call a successor trustee. So it's the backup person that if something happened, they would manage the trust. But the trust has all of these rules that need to be followed. And if that successor trustee isn't following those rules, they're not being held to that fiduciary responsibility, then that's where legal intervention can come in and say, hey, you're not following the rules. You need to either conform to the rules, or we're going to go to the next person. And so that's why it really makes it very clear. Okay, so if you're just joining us, please post your questions or comments in the comment section. If you have any questions you want me to get to, I have time for one or two more questions. And please join me here every Wednesday at 6 p.m. answering your estate planning questions. If you need to contact us or you don't want to post your question in the comments, please feel free to put it info@Hermance Law and just send me an email. Okay, next question. I'm having a hard time choosing guardians for my kids. Any advice? Yes, I do. I have a few things that might be able to help you. So one of the things I hear a lot from people is that they haven't done their estate planning because they cannot choose guardians. And it's literally the only thing that's holding them up. And so what I tell people when I hear this is put anybody down that you think potentially, is your first choice right now, right? Without thinking through it, just like make a list. And if anything, at least get that in writing legally, because without it, again, the court has no idea who you would want. And at least your wishes kinda are better than no wishes at all legally documented to the judge. Does that make sense? And so if you're having a hard time finding out, figuring out who you want to be guardians, The first thing I say is to make a list. Make a list of any potential that even if it's like, you're going to cross them off, just write down this list, this very kind of extensive list of people that are potentials. And then go through the qualities that you would want in a guardian. What is their family lifestyle like? How do they raise their own children if they have them, if their own children? Do they need to have their own children so that, that there's other kids around? Where do they live in proximity to where you live? Is it going to be tough if they're older moving to a new place? What, religion are they? Are they going to be able to follow your traditions? What, from an income perspective, while you should have money to be able to provide to help with the raising, for the care of your children, through life insurance policies or retirement accounts, whatever it is, can they afford to take on another child? If you have assistance for them, is it something that's going to be very burdensome for them? Are they going to be able to survive? Or, are there illnesses in the family that you need to be kind of thoughtful of? So these are kind of all considerations when you're kind of making that list. Then take like a piece of paper and just make a list of 1 through 3. I always recommend to clients that we pick 3, 1 primary and 2 backups. Take that list of 1 to 3 and just write in the name of the person that you would want first, the person you would want second, and the person that you would want third. It doesn't have to be one person singly. It could be a joint couple if they're married, if you want both of them to be named. And then just let that list sit, right, for maybe a day, 2 days, 3 days. And then over the course of those 3 days, how do you feel about it? Like if something happened, do you have that instant feeling like, oh, that wasn't the right decision? Because the act of actually writing it down and making that list will help you figure out, was it the right choice? Would I be okay if something happened? Because then if you have that sinking feeling like, oh, that wasn't the right choice, I didn't make the right decision, then you at least know, okay, well, I don't want that person. And then go back and make those adjustments. Again, your list, anything from you, that input is better than nothing when it comes to going to the court. Because then it's some input from you. It's some information as to who you would want rather than nothing at all. It also lets your family know, right? Especially if you have, family dynamics where you think that there could be issues on who would want the children. Don't leave it to them to try and, battle it out. Have that list legally documented that says it so that they know and that the court knows what your wishes are. I will also say that if you and your spouse don't agree, I know it's hard to talk through, but there's going to have to be compromise. I've seen it happen many times where they just can't agree, but then we talk through it and they come up with something, right? It may not be exactly what both of them want, but it's still better than nothing at all. And so you are potentially going to have to compromise if it comes down to it. Okay, so just be flexible with that, because again, something in writing is better than nothing at all. Okay, I hope that answered some questions and was able to give you some information on guardianship. One thing that we do have as a free printable that I wanted to make sure you guys know about is our estate planning guide for parents. It has lots of information on nominating guardians for minor children, from not only long-term guardians, but also short-term guardians, which is very important. You can go to our website, hermancelaw.com, go to the resources and freebies portion there, and at the top you'll see the guide, the estate planning guide for parents, to be able to download that. And it's a very kind of long free printable guide that goes through all of the different agents when you're looking at estate planning and things that you should consider. It actually has printouts for you to be able to write your list, right? Start kind of getting that information down on who you want. Okay, if you have any questions, please make sure to either email them to me, you can send them to me. You are always welcome to call our office or text us, 805-518-9633. And if not, then I will see you back here next Wednesday at 6 p.m. for our weekly estate planning Q&A. Thank you so much for joining me today, and have a wonderful day.